number is 20-22-0352, Commonwealth versus Nicholas PILALAS, or PILALAS. Please correct me when you come here as to the pronunciation of your client's name.
Thank you, Your Honor, and may it please the Court. I'm Robert Herrick. I am here for Nicholas PILALAS. As the Court knows, I filed a motion for new trial in this case. And what we alleged was ineffective assistance of appellate counsel. I'm not going to dwell on the first prong of Safarian. The judge agreed with us that that appellate counsel did not perform to a standard that would satisfy Safarian. Therefore, I would move on to the prejudice prong. One thing that I think is worth noting, though, is that I think there's a question of standard of review here that this Court should address, and that is, in this case, where the question of whether or not there was prejudice by appellate counsel's ineffective assistance in the first instance, the question really reduces to whether this Court would have ultimately adjudicated the case in a way that was favorable to the defendant. Now, or more succinctly, whether there was a meritorious issue that should have been raised before this Court.
So just so I understand, what you're saying is we should almost like turn back time and pretend that this is his direct appeal, and if this issue was raised about the prosecutor's closing and we were considering it as a panel on direct appeal, what we'd decide. Is that what you're saying?
I think that's largely true, Your Honor, though I think the question is a little bit more basic, whether there was a meritorious issue that was superior to the issue that had been raised by appellate counsel in the first instance. But ultimately, I think that this Court...
But let's assume there was an argument he should have raised, but if we would still have ruled, and we can say he should have raised that, but if we still would have ruled against him, as Judge Grant said, we've just pretended this was his direct appeal now, why would he get any relief?
Well, the relief, Your Honor, would be that ultimately, if this Court were to determine that yes, appellate counsel was ineffective for failing to raise this argument, but ultimately the argument itself would not have been meritorious, would not have given him relief. I think you're right. I don't think that he winds up getting a new trial.
He does not wind up getting.
He would not wind up getting a new trial. But what I'm suggesting, though, is that Judge Cosgrove in this case made a determination that there was no prejudice, and his rationale was that this case was not going to present a meritorious basis on appeal. And what I'm suggesting is that this Court is better situated than Judge Cosgrove to determine whether...
Well, why is that? Why do we ignore his decision? Because in any other motion for a new trial, even in a motion for a new trial based on ineffective assistance of counsel, be it trial counsel or appellate counsel, we review the judge's decision for abuse of discretion.
I'm not suggesting that you ignore his decision. What I'm suggesting is that it's not...
Well, you are sort of. If you say we should apply a different standard of review...
Well, I'm suggesting that it's not entitled to any particular deference. So what the analogy that I would make is to cases where it's
Okay, well, let's not split hairs. Not entitled to deference versus ignore. We'll even take the way you're putting it. It's not entitled to deference. Why not?
Primarily because I assume that the judge, when he's giving the curative instruction in the first instance, he's doing it in good faith with an understanding or with an aspiration that he's making the right call. It's not going to be reversed on appeal. So what we're asking him to do, I think, is unfair. We're asking him to basically assess his own actions at trial and then determine whether or not those actions amounted to reversible error.
That does happen in other cases fairly regularly, does it not? A judge has to, on any motion for new trial, has to evaluate whether or not an objection that was sustained or not sustained, admissibility of evidence, whether or not the judge gave or did not give a jury instruction that was requested or not requested. Should have given one sua sponte. The judge in all those instances has to review the entire trial as well as his or her own conduct.
I agree, but here what he's trying to do is predict what this court would have done had this argument been presented on.
So in that case, you say we're in better shoes to
That's
predict
exactly
what we
right.
would have done. So this panel of three is in better shoes than the judge, although we have to predict what another panel might have done, potentially, but that's where you see the difference.
Right. I think there's
I
certain
understand.
fiction that it's all one court, and that the decisions would.
Well, we like to think so.
So I understand the thrust of your argument about the prosecutor's closing is that she repeatedly said the defendant could have just driven away, and that was improperly implying that he had an obligation to flee under the self-defense instruction. Why wasn't that argument also relevant to issues like whether there was sudden combat and whether there was reasonable provocation, whether there was extreme atrocity or cruelty or deliberate premeditation?
Well, so just to be clear, the argument that I'm making is not that the trial prosecutor misstated the evidence that was presented at trial. I don't think that evidence was inadmissible. I think the evidence was admissible. What I think is that she distorted the law of the duty of retreat. And the way that she did it was by repeatedly going back. She didn't say he could have left. She said he could have retreated. And what I'm arguing is that retreat is a term of art that really we just see in military situations and we see in self-defense cases.
So, but you argue in your brief at the legally relevant time your client had no reasonable means of retreat. And so what I was trying to understand is what you think the legally relevant time was.
I think that's an excellent question. So my take on the legally relevant time is and I won't bore you with a recitation of all the facts. He returns to the scene. He is approached by three men, three young adults, but they are adults. He's approached by three men. They continue this sort of adversarial banter. One of the men flips his cigarette out of his mouth and then vandalizes his car. He bashes his window. I think at that point the defendant is entitled to get out of the car, if only to look at the vandalism. What I would suggest is at that point that's when
When you say he was entitled to get out of the car, are you saying it's reasonable provocation?
No, I'm saying that if this were a bicycle accident, for example, and somebody had run into his mirror, he's entitled to get out and look at and see what had happened to his vehicle. And the reason I hone in on that point is because that's really where the evidence starts to diverge pretty substantially. There's evidence on the one hand that PILALAS is just getting out of the car, and he gets sucker punched immediately. There's other evidence that basically says no, PILALAS gets out of the car and gets in a bit of a tussle with Pitt, not the decedent, but with one of the three men. So I think at that point that gives the jury a chance to determine. Okay, this is the moment where we have to decide what was his intent in getting out of the car. Was it to launch into a fist fight, or was it to see what just happened to my car? So that I think is the relevant time period. But what this comes down to though is the judge sustained the objection that was made by trial counsel. Mm-hmm. Trial counsel said this is a perversion of the law of self-defense. The judge obviously did not adopt that language, but essentially said, I do think, and this is at page 24 and 25 of my brief. He said, I do think that the trial prosecutor had blurred had suggested that the duty to retreat arose at a time earlier than it actually had. So the judge upheld the objection. He believed that the argument was was erroneous, was improper. And he did offer a curative instruction. And what I would like to suggest is that the curative instruction itself failed to cure the ill here. And the ill.
Why? What did it omit, or what did it need to say?
So what I would say is, and you've got the curative instruction on page 24 of my brief. What I'm suggesting is that really there were a few problems with the curative. The first is that he doesn't plainly say that the prosecutor had wrongly suggested that there was a duty to retreat before that duty to retreat arose. I think when this was the theme that was so pervasive throughout this trial that the judge had to give a very specific and very precise corrective instruction on that point. He also doesn't give the jury a clear principle for determining when the duty to retreat arises. And I think that winds up being problematic because ultimately his reason for sustaining the objection is that the trial prosecutor incorrectly asserted that the duty to retreat arose earlier than it actually had. So I think he needs to give them a principle at least for determining when that should have happened. And finally, I think it is problematic that he emphasizes that there's this evidence that the defendant had multiple chances to leave at an earlier point of time, and that evidence, at least some of it, obviously preceded the time that the duty to retreat had arisen.
So is it the fact that the judge didn't use the word retreat?
No, I think it's the fact that the judge didn't specifically say what the prosecutor just told you about the duty to retreat, to the extent that it suggests that there was a duty to retreat while there was just basically this back and forth exchange of insults, that was inadequate. And I think there's a bigger problem. There are two bigger problems really, but one is that he really doesn't give the jury an opportunity to recognize that criminal liability is not the same as torts liability. One of the problems with the argument is that the trial prosecutor is essentially trying to argue that of the people who were present here, many of whom made decisions that wound up proving very unfortunate, of the people who were making decisions here, that one of them was better situated than the others to actually avoid this terrible outcome. And that's not the way that the criminal law works. That's the way torts law works.
Well, I have a question for you about that.
Yes.
In 2017, in the unpublished opinion in this case, another panel of this court said, even though nothing was blocking the path of his car or otherwise preventing him from driving away in either direction, PILALAS did get out of the car. And that at another point, they said he repeatedly injected himself into the lives of complete strangers late at night on a rural road and reacted angrily when they told him repeatedly to leave them alone to no avail. Twice he got out of his car, which was unobstructed and could have carried him away safely. Now, was that wrong? Is that improper for the court to say that?
But remember, Your Honor, that the judge was considering, this panel was considering whether the Rule 25B motion had been improperly denied, and I think the judge the appeals court could take into account those factors in determining whether or not a reduction in the sentence should have been allowed, was required to be allowed. So I think it was a different procedural posture. So I don't think that was an incorrect statement.
Do we know from this record what, if any, conversations your client had with his first appellate lawyer about what issues he wanted to have raised on appeal?
I don't, Your Honor. We don't know from this record.
So we don't have an affidavit of your client about what he asked the lawyer to raise?
No, his lawyer basically told him, we've got this great argument. The judge.
How do we know that the lawyer told the client that?
I'd like to say that it was either in my affidavit.
It's in the father's affidavit.
Or in the father's affidavit.
But we don't know what he told the client. We don't have anything from the
Right.
client saying, I wanted the lawyer to argue X and he argued Y instead.
That's correct. One thing I would just like to point out, just for the big picture, Judge Cosgrove has basically said, I would have reached a different conclusion in this case than the jury did. He basically said in his denial of the initial Rule 25 motion, I might have viewed the facts differently, but I'm not going to substitute my judgment for the jury's. In other words, his judgment was different from the jury's. I think in a case, and he also said it was an exceedingly close case. I think when a case is exceedingly close like this, one has to wonder, well, how did the jury come up with a different result than the judge would have come up with?
So you're saying he should have substituted his judgment for that of the jury?
No. What I'm saying is that we have to consider that any error that was made in the jury instructions would have very likely had an impact on the outcome of the case.
Given how close the case was, is
That's
your
correct.
point. Okay. Your time is up.
Thank you, Your Honor.
No further questions. Thank you very much.
Thank you.
Good morning. May it please the Court, Assistant District Attorney Christine Kidd, representing the Commonwealth. Your Honors, the Commonwealth maintains that notwithstanding Judge Cosgrove's finding that the first prong of ineffective assistance of counsel was in fact found, the Commonwealth maintains that any error in the prosecutor's closing argument which led to the ineffective finding was cured by the trial judge's specific, unequivocal curative instructions and by his final instructions to the jury.
So I want to be clear. I understand you because I don't.
Okay.
Do you dispute the first prong of Severian was met?
I do not. I agree that my brief didn't really make that clear. And I recall reading it, sort of waffling myself back and forth as to whether I really agreed with the judge. But at the end of the day, I do agree with the judge that it would have been better for the first appellate counsel to have raised that issue. But in going forward and in assessing it, this was a case where the judge did give a specific curative instruction, and the curative instruction didn't, as I think counsel seemed to be suggesting here today, that the trial judge Cosgrove should have identified for the jury at what time period the duty to retreat kicked in. And I disagree with that. I don't think that is the job of the trial judge. That is the jury's job to determine at what point the duty to retreat arises.
He's making an argument that retreat is a term of art and that by the prosecutor using it over and over again at these earlier times, that really clouded the issue.
It blurred the lines.
Yeah.
And I agree with that.
Okay.
I do agree with that.
So he used the expression legally relevant. When do you think the legally relevant time was on this issue?
The legally relevant time would have been at the moment that the necessity to use deadly force happened, which from my reading was when he was out of the car and there was that immediate confrontation. And I agree.
Do you think the jury knew that?
I think that's
let's be really clear.
Yes.
He made a bunch of what my, elementary school principal would have called poor choices.
Sure.
But do you think the jury knew that the issue was really that last group of interactions there when he's getting pounded on by a bunch of different people?
I think that the jury is presumed to follow all of the judge's instructions. And the judge's instructions, so if you look at all of the instructions as opposed to just confining the duty to retreat in that moment, and also with common sense, I do think that the jury, if they listen to all of what the judge instructed, after hearing all the facts and then listening to the entirety of the judge's instructions and applying common sense, which we expect the jury to do, yes, they would understand that duty to retreat, and with the curative instruction by the judge. I mean, the judge clearly stated there is no duty to depart.
That's my concern, though. I mean, I'm a big fan of common sense. I even have a sign in my office about common sense.
Yeah.
But that's exactly the concern, because I think the jury could be saying he made a bunch of poor choices.
Yes, I
I
agree.
mean, this is on him. He could have left. He could have left. He could have left. He could have left. And,
Right.
and that's the question.
Well, and I think so. I think that the prosecutor, and I think this was raised. This was one of you justices did acknowledge that when the prosecutor kept arguing that that's because of the uniqueness of the facts in this case. This is someone who came upon the first group, went to leave, made a U-turn, came back, then continued to engage with them, and then confronted a second group. So the defendant was looking for a fight. So I think that the way that the prosecutor was arguing to the jury, yes, the line was blurred as to that legal duty to retreat because of the verbiage she used. But I think that she had to argue those kind of facts about the defendant's conduct because it was relevant to his intent. It was relevant to so many other issues for the jury to consider as to what was the defendant's intent that night. So to just focus on, so she's arguing it, she wasn't arguing it solely as to the duty to retreat as much as she's arguing it in big picture. What was the defendant's intent that night? He's looking for a fight. He leaves, he comes back. He comes back. There's not one group, it's a second group. These two groups minding their own business. They're on foot. He's on car. He comes back, and he's the aggressor. He's the one that's confronting these individuals. So I think that the prosecutor arguing those things was relevant for a whole host of other reasons.
Oh, it definitely was relevant. And even assuming you're correct that he was looking for a fight, and it sure looks like he was looking for a fight, once he starts getting pounded on really hit by 3 to 6 people, does he have no rights then at that point?
Does he have no rights in terms of
Fighting back,
using
or defending
deadly
himself
force?
with this knife he perhaps foolishly armed himself with?
No, I think that at that point, now it's mutual combat. If you were to break it down frame by frame, and you were to accept that he was being attacked by 4 or 5 people, he would have the right to defend himself, but I guess then it would be a question for the jury what force was he allowed to use under the law to defend himself, and was he allowed to use deadly force? But it wasn't a one-on-one fist fight where others jumped in and got the better of him. The facts are different in that he deliberately armed himself before even getting out of the car. And you have to go back to his intent where he said, I'm going to effing kill you, or I'm going to effing kill someone.
Yeah, but people say that all the time, even when they're just irritated. Unfortunately, discourse has become coarser, and if everybody who said that, we'd have a lot of people in jail. Agree,
except but it goes into the totality of the malice that I think he showed here. And I think that's at the end of the day, this was an incident of malice. The defendant, as I said, was looking for a fight. He armed himself with a 9-inch knife. He made that threat in connection with that state of mind, and that he acted with malice in this particular case. And as to the second issue, for the same reasons that I just stated, that I just touched on, the trial judge, we suggest, correctly denied the renewed motion for the 25B2 in the sense that this was a case where the defendant was looking for a fight. He came upon these 2 unsuspecting groups. He angrily sought out these confrontations, armed himself with a knife, said he was going to kill someone, opened the knife, and stabbed at those near him, stabbing victim in the heart. And I would suggest the weight of the evidence at trial was consistent with second-degree murder, again, because of the malice. And therefore, the judge did not abuse his discretion in denying the motion to reduce the verdict for the second time.
So do you think that the jury instructions were, that the jury, when they left to deliberate, that they were clear he didn't have to retreat during the initial verbal confrontation?
I do, because Judge Cosgrove said there is no duty to depart from a public way, a street generally, because someone asks you to. There is no duty to leave or break off from a verbal argument. So the duty to retreat arises out of the necessity to avoid the use of physical combat and deadly force. So they've heard the facts, And again, it's for them to decide that precise moment where the legal duty to retreat arises. But he didn't just give them that blanket language. The duty to retreat arises out of the necessity to avoid the use of physical combat and deadly force. He specifically stated before that, there is no duty to depart from a public way, or there is no duty because somebody asks you to. Couldn't be more clear. And at that point, I think, as the case law recognizes, the jury has been given a whole bunch of instructions, and the jury is presumed to follow the trial judge's instructions.
Just to follow up, I'm looking at the record appendix at page 202. Am I correct in understanding that there was no objection to the jury charge by defense counsel in this case?
That is correct.
And no objection to the curative instruction?
That is correct. There was the objection to the prosecutor's closing, but not to the curative and not to the entirety of the judge's instructions.
So when Mr. Atwood moved from mistrial, and then the judge said, I'm going to give a curative instruction that he doesn't have a duty to retreat, and Mr. Atwood said, I don't think any curative can cure it, Your Honor, before the instruction. You're saying he had to reiterate that after the instruction in order to preserve the objection? When he said, I don't think any curative can cure it, before the judge gave the instruction.
Right. But then when the judge gave the instruction, he didn't reiterate it. So I think there's some indication that at that point he was content.
He said he was satisfied with the charge on page 202.
Thank you.
That isn't necessarily what
that
that means
exactly.
We'll discuss, but that's what he actually says.
If there are no further questions,
I have one housekeeping matter.
Absolutely.
In the Commonwealth supplemental memorandum supplemental appendix, that was filed, there is detailed personal information regarding the defendant. It's given in the beginning of his statement. That should be redacted. That should not be there.
Thank you. All right.
Would you please take care of that? And
yes.
Make sure that. I'm sure it was inadvertent, but that should.
Thank you for pointing that out. Okay. I'll take care of that.
Question. Thank you both very much.
Thank you, Your Honors.
All right, we're going to hear one more